All right, hello everyone. We are live. My name is Bradley Chaplick, and I'm going to be answering your questions live. I'm a condominium lawyer at the law firm of Horlick, Levitt, Lella, and it's my pleasure to be here with you this Wednesday at noon. I think our 22nd episode of Ask Us Anything. So, there's lots to talk about as always. There's the sort of looming deadline of the condo crunch when a large number of condominium corporations have to hold their annual general meetings this October. There's lots going on with masks and with gyms and with all sorts of other condominium issues. So, jumping right into it. Also, if you're not a subscriber, please do click the subscribe button, and you can hit the notification bell to be notified of our future videos on this channel. We do update the channel quite regularly. So let's get into some of the questions that we have here in the chat. If I can get to the top here, some of the questions are already starting to fill up. Jerry asks, Brian mentioned that for back-to-back AGMs, the quorum is based on the totality of the owners present in person by proxy determined at the end of the last meeting, similarly with voting results. Question 1. What happens if quorum is not met? I assume the meeting could not have taken place. Any business conducted would not be valid. Question 2. Does the board have the right to ask for specific qualifications, experiences, etc. from candidates who wish to stand for election for a vacant board position? In many situations, not all owners of a unit home have been officially registered on title. Question 3, in an in-person AGM restricted to one person per unit household, can the non-registered owner attend the meeting and vote, or must the registered owner attend and vote? Okay, lots of stuff here. So I'll try to speak up because I know the microphone on this device is not that great. So the first question is, what happens at a meeting if quorum is not met? And the answer is that the meeting cannot start if you do not have quorum, and if you lose quorum during your meeting of owners, then the meeting automatically ends at that moment. So one of the ways that you can do this on the new proxy form is there's a box that can be checked that says the proxy is for quorum purposes only. And so if you're concerned that you might not have quorum and there's people who aren't going to come to the meeting and maybe they don't want to vote, they can still assist the corporation by delivering a proxy for quorum purposes only. And in so doing, they will be able to ensure that the corporation has quorum for its meeting. Question 2. Question 2. Does a board have the right to ask for specific qualifications from candidates who wish to stand for election? So director qualifications are found in 2 places. There are basic qualifications set out in the Condominium Act, which say things like you have to be at least 18 years old, and you have to be capable of managing property, and you cannot be an undischarged bankrupt. So those are and you have to do your director training and your disclosure obligations. So there's quite a few basic qualifications in the Condominium Act. And then a condominium corporation can also amend director qualifications by amending their bylaw. So you amend your organizational bylaw, then that amends your director qualifications, and you can have stricter qualifications. So it can say things like you have to be a unit owner. So for example, right now, under the Condominium Act, there's no obligation to be a unit owner. But you have to be careful when you make your director qualifications really strict, because the stricter the director qualifications, the fewer people can run for the board. And the fewer people who run for the board, the less choice people have in selecting their directors, and less choice does not always equate to a better outcome. So I would say that you have to really ask yourself, why are we making director qualifications stricter? does this really serve owners' best interest, or can we just have the basic qualifications broad and owners can choose the directors who they want, so like, because when you restrict qualifications, you're really taking away owners' right to choose. So careful balance there. And so then the next part is if you're doing an in-person AGM, like at the present time when the participation is going to be limited to the number of people who you can have at the meeting, and you're going to say one person per unit attend the meeting. I'm not sure, okay, you're doing it because it's a pandemic, but under the normal rules, your bylaws will say who has the right to attend the meetings. And the bylaws will say that any owner can attend the meeting. So if you have two owners on the unit, they both have the right to be there. But you're going to say, we just want one. Okay, great. And then the question is to say, must it be the registered owner or can it be someone else? Well, the answer is, of course, it can be someone else because the registered owner can give a proxy to anyone else. And so you can have a situation where you say, we want one person per household attending the AGM, and the unit owner gives her proxy to her adult child. And the adult child attends the meeting on behalf of the mother and is the mother's proxy holder, and that's totally lawful. So there you go. So I hope those answers help you out, and we will look at some more questions. Also, my colleague, Mr. Horlick, dropped something off for me, some news from the Condominium Authority Tribunal, expansion of types of disputes. So this email came in 5 minutes ago. This is the joy of doing live streams, is that things happen while you're actually doing the live stream. The law changes. This sort of famously happened to me in the first few weeks of us doing this. While I was in the middle of the live stream, the federal government held a press conference and announced new quarantine rules, and I was sitting there trying to figure them out while everyone was asking me questions about it in real time. So that was really fun. So it happens now again. This time not as critical, but the Condominium Authority Tribunal will be expanding the types of disputes through online dispute resolution. This is very exciting. We've been waiting for them to do this for a long time. Right now you can only attend to records disputes, but on October 1st, it will expand to additional disputes, so in the condominium's declaration, bylaws, or rules that prohibit, restrict, or otherwise govern pets or other animals, parking, vehicles, storage in a unit, or in the common elements, okay? So that's govern pets or other animals, parking, vehicles, or storage, okay? We'll have to think really hard about what that means. And then govern the indemnification or compensation of the corporation, an owner, or mortgagee in relation to the above noted disputes. Okay, so costs in relating to the foregoing. Pets, parking, or storage. What does that mean? We'll have to think about it. We'll have to try to figure out exactly what that covers. I'm sure there's going to be a lot of case law. But anyways, Condominium Authority Tribunal dealing with pets disputes. Wonderful. So that's really nice. All right, more questions. Really interesting. Condominium Authority Tribunal. Okay. Last week, Mr. Horlick mentioned that if you have an in-person AGM, proxies must be submitted 2 days in advance. What happens if you have a combination meeting? I don't think, I don't want to speak for Mr. Horlick, Brian, but I think he was saying that he would recommend that if you're going to have a meeting in person, that you don't want the meeting to be delayed by people having to sort through proxies or people huddling together to do this. You want all of that done in the office in advance, and so you should set a deadline for proxies that is in advance of the meeting, and that will allow for a safer and more organized meeting. So I think that's all. It's a recommended procedure, and so the question is, what happens if you have a combination meeting? You would treat that the same as an in-person meeting for the purposes of proxies. You want them submitted in advance so that you have time to vet them, and you don't have to do it live at the meeting with people huddled around each other. I think that's the idea here. So Sylvia, Can someone provide recommendation on a company who does virtual AGM? Seem like all are booked up. Okay, so there's basically, that I know of, 4 service providers for virtual meetings in Ontario for condominium corporations that are reasonably well known. Get Quorum and Shift Suite, Condo Voter, and HLD meetings. So those are the big 4. There might be others that I'm not aware of. And so if all 4 are booked, then you should look for a different meeting date. And it might mean that you have to postpone your AGM a few days beyond the deadline for holding it. And if you have to do it for that reason, that's okay. So I would say that you just need to pick a date for your meeting when at least one of those 4 service providers, one of them being HLD meetings, is available. So that's what you got to try to do. Just do your best. Phil, can we use a pre-populated proxy form with candidates' names and spaces for any new person's name to be added? So this pertains, again, lots of questions about meetings, which is really expected right now. A lot of condos are working on their meeting materials and haven't done so for a while and are trying to figure out new policies for holding a meeting during a pandemic. So Phil's question is about pre-populating the proxy form. And so what that would mean, for example, is in the list, in the section for election of directors, you would write in the names of all of the candidates so that people can select next to the candidate of their choice. And if you were going to pass a bylaw, you would also have that section filled out, like bylaw number 10, yes or no, right? Yes, you can do that. The form is designed to be customized in that way. You would also pre-populate the name of your condominium corporation and the date of the meeting and all sorts of other basic information. So the form is designed to be pre-populated and sent to owners with certain information included in it, and to also have extra spaces for people to write in additional candidates and other voting instructions. So yes, that's the intent of the form, and you can do that. Also, that's not a problem because you have to initial next to your selections. So yeah, that's how the form's meant to be used. Paulette, I have heard that the time frame for AGMs to be held may be extended. Have you heard anything to this effect? I haven't. I wouldn't be shocked if at the end of the day there's some sort of last minute extension that is granted. But as far as I know, the timelines are as they've been set out on the Condominium Authority website and in our many weekly updates. We have a big table that says, based on your year end, these are your deadlines. Other law firms have done the same. All of the tables say the exact same thing. And but if we get news that there's an extension, you'll read about it from us on Monday or Tuesday, because we send out our weekly updates, and that would definitely be in there. So if we hear about it, we'll let you know. But as for now, plan as if you're going to go ahead. And honestly, even if the deadline is extended, I think now's the time, right? Just have the meeting, do it electronically, get it done, and then you can move on to other issues. Because you extend the deadline, it's just, sometimes it's better just to rip the Band-Aid off all at once. Okay. Paulette, can corporations restrict the number of owners that can attend the meeting, capping it not to exceed the limit of 50, providing physical distancing can be achieved? So this is talking about in-person meetings of owners, and I would say that you must limit attendance to no more than 50 people, and that the people in attendance cannot be closer than 2 meters to each other. So you have to have a room that's big enough to allow everyone to spread out. Those are things you would have to do if you had an in-person meeting. So all of those things are problematic, and that's why we recommend virtual meetings, because how can you say to an owner who has a right to attend the meeting, that they weren't part of the 50 people who are allowed to be there. It's very difficult to justify that when there is this option to have a virtual meeting. So I think if you have expected demand of more than 50 people, you should be looking exclusively at virtual meetings, at least for now. Melody, are there any liabilities associated with holding in-person meetings in December? What if there's an outbreak? One of my boards does not want to pass an e-voting bylaw. You don't need an e-voting bylaw to hold a electronic meeting in November, so you can do it up to November 21st, so you could try doing that. Otherwise, if you're going to hold an in-person meeting in December, you have to follow the law, right? So assuming that there's no change in the law between now and then, these are the risks you're going to face. You're going to, if we're still in stage 3 and everything's the same, then you're going to be capped at 50 people, and you're going to have to ensure that people maintain physical distance, that people are wearing masks, which is going to make it very difficult for people to understand each other and hear each other properly in the meeting. There's all kinds of problems associated with in-person meetings, practical problems, not really legal problems. And but if you follow all the rules, then I don't see that you would have liability. People don't have to attend the meeting; they choose to do so. They can vote by proxy if they don't want to come. So there you go. I mean, I think condos should pass e-voting or e-meeting bylaws, but they're not required to, and some won't. And maybe the law will change that says you don't need one anymore. That wouldn't surprise me at all. But until then, pass your bylaws and be ready. Okay. Dorothy says we used Get Quorum in June. It went very smoothly. I'm not surprised. That's great. Paulette says we've heard Get Quorum is now booking into December, including day meetings. Yikes. Try using someone else. Try Shift Suite, HLD meetings, or Condo Voter. Any of those. I mean, I know our office still has dates available. Not many, but a few. Definitely not booking into December. I mean, if you wanted a date in November, we would have it. So almost certainly. Yelena, in a noise dispute, what kind of proof, besides calling security, should the manager ask the complaining resident to provide? That's a great question. I love questions like this. Okay, let's talk about noise disputes. We'll return to meetings in a moment. So you have to prove on a balance of probabilities. A balance of probabilities is not a criminal standard of proof. It just means that the thing is more likely than not. So 51% likely to be true. Okay. So what are the kinds of evidence that we can use to prove unreasonable noise? Well, we all have recording devices in our pocket, right? You can record something on your cell phone. Many phones have applications that can be downloaded that have decibel meters on them and that record date and time. So you could use a decibel meter on your phone. I'm not sure how accurate they are, but it's a lot better than just saying it sounded loud to me, to actually have some sort of quantifiable number that you can attach to it and say my phone said it was 50 decibels, right? So you can record it, you can keep a journal, and then you can also have verification, right? So one of the the best indicators of whether a noise dispute is legitimate is whether there's more than one complainant and the reliability of the complainants. So if you have two neighbors complaining that one person is making noise and they're both describing the same thing and your security is verifying it and you have all this different independent verification, that's most likely going to be sufficient. So the cases where you want more rigorous evidence of noise is where it's just one complainant. Where you have multiple complainants, you can rely on the fact that there are multiple complainants to independently verify the noise. Sound recordings, video recordings on phones, applications that detect decibels, expert reports, security reports, going up and listening to it yourself as the manager, or having the directors personally listen to it and describe the noise. All of these things should be done. Take as much time as you need to investigate these complaints and make an informed decision, and then go from there in terms of your enforcement. Okay, questions from Phil about proxies. Can the pre-populated form be the only form to be allowed for voting? Okay, so this is a question about proxies and electronic meetings and ballots. And so the question from, well, I guess there's a couple questions here. So one question is, can you restrict the permitted proxy to say you must use the pre-populated proxy form distributed by the corporation? Any other proxy form created by any other person will not be allowed. No, you cannot do that. So owners have the right to go online, download the official proxy form, and pre-populate it differently than the board. So for example, a competing slate of owners might decide that they are going to create their own pre-populated proxy form that doesn't have any of the other candidates' names on them. It just has the candidates of their preferred group. And that's the proxy that they're going to go and get owners to sign. That's totally fine. Assuming that that's your question, I think that's my answer. And then if your question is, can you disallow e-voting or ballots during the meeting? You don't want to do that. There's circumstances where it has to happen, and we can get into them. But I think your question about restricting the scope of permitted proxy forms, you generally don't want to get into that. You want to follow the new regulations stating that as long as someone uses the official form and fills it out, then that's fine. So they can fill it out as they see fit, or they can use the pre-populated one from the corporation. Either are fine. Gene, if you call an owner's information meeting, is it required to achieve quorum, i.e. update on landscaping, for minutes to be held but no decisions are being made? Okay, Gene, great question. No, you are not required to achieve quorum for an unofficial owner's information meeting. It is a good idea to take minutes based upon a case where a condominium corporation did not take minutes on what they felt was an unofficial owner's information meeting, but which the tribunal interpreted as being a true meeting of owners, even though there was no voting. And so the tribunal was critical of the corporation for not taking minutes of the owner's information meeting. So I say you should have someone take minutes, but you are not required to have quorum. So that's my suggestion, and that's just based on a CAT decision that dealt with that exact issue, called Rivera-Barreto, I believe. Anyways, interesting stuff. DCC 102. Many facilities are closing to public schools, and town facilities are not available until the end of November for AGM or owners' meetings. Hoping the government takes this into consideration. Yeah, so this is a question about, like, if we're going to have an in-person meeting, the places where we would normally have them, like community centers, are not actually renting rooms. So how are we supposed to have a meeting? And I think the answer to that is you should do a virtual meeting. Gene, I have heard that without a change in the Act, that while the Corp can pass a bylaw for electronic voting but cannot pass one for an electronic meeting. No, that's not correct, Gene. It is absolutely legal to pass a bylaw for electronic attendance at condominium meetings, and this is set out in the Act and in the regulations that says method of attendance is one of the electronic method of attendance can be passed by bylaw. And then furthermore, you have to consider, Gene, that the Ontario government specifically implemented a temporary amendment to the Condominium Act to say that you could hold an electronic meeting without the need for a bylaw during this special period of time. And so that, of course, implies that outside of that period of time, you can do it with a bylaw. I mean, otherwise, the wording of the temporary amendment doesn't make any sense. So the lawyers who are saying that bylaws for electronic meetings of owners are not valid, I don't know what they're talking about. I don't think they're right. I'd love to see their opinions. I haven't seen a single lawyer saying that. But if there are people out there saying that, then they should talk to me or come watch the live stream. Catherine, leak on a suite ceiling Overhead is the roof. All drains, etc. have been checked and the flood situation created. No evidence of water penetration to the suite. Okay. Recent heavy rains did not penetrate the suite. Plumber ran the shower, found water coming from the shower onto the floor. Plumber took the position it's probably related to the shower not being sealed properly. Can the corporation charge back for a probably report? It's interesting. Well, I'm not sure how you make the connection between a leak in the ceiling and water on the floor and that being the same thing. So that's tricky from my perspective. Your best bet is to wait until there is some actual cause determined and resolution achieved before you make the chargeback. So let's say the plumber takes the position that it's probably related to the shower not being sealed, and then you go ahead and you seal the shower, and now the problem is solved. Now you've gone from like probably to almost certainly, because you've fixed the thing, and you've, as a result of fixing the shower, you have resolved the leak, and those two things can be connected. And I think once you can connect the fixing of a certain problem to the resolving of the leak, that's when you're in a better position to be looking back to the owner for indemnity, saying bathroom showers directly above. So anyways, that's it. I would say try to wait to the point when the problem is actually resolved, and then once you've solved the leak, that's the time when you want to start looking towards who's responsible, right? I think it's premature to do the chargeback before you've actually discovered the cause and fixed it. So that's my tip on that. You don't want to do it prematurely. Plumbing costs and things, I mean, it might not be big money, so you want to err on the side of caution on that. So I've blasted through the questions. It's 12:26. Recently I've been going for about 35 minutes. So I'm gonna just sort of opine for a couple moments here on the expansion of CAT, Condominium Authority Tribunal, to cover pets, parking, and storage. Pets is a big one, but what are the disputes relating to parking and storage? I mean, okay, storage lockers, you can't store combustibles or dangerous goods. Maybe you're having arguments with people about where they're storing their bicycles in the hallways or stuff like that. That's not a major category of condominium disputes. I mean, yeah, it happens from time to time, but it's not like a huge generator of disputes between condominium corporations and unit owners. Same thing with parking. Okay, so parking, there's a different one. Parking, you get disputes when people are asking for accommodation. So people want to park in visitors, or they have disabled driver parking permits. Those disputes can already also be dealt with at the Human Rights Tribunal, but now I guess people have the other option to go to CAT. Okay, I mean, visitor parking passes being revoked, that kind of thing. So that's another sort of medium frequency generator of disputes. The big one here is pets. Pet disputes are extremely common, and they are extremely intense. There's a lot of intensity to these disputes because people do not want to get rid of their pets. Pets are family members for the most. It's how people think of their pets as family members, and that's fine. And so people are always looking for ways to keep pets in no pet buildings. So I think that's going to be a big issue. I think CAT is going to become full of pet disputes. And honestly, I think it's a good thing because taking pet disputes to court is not ideal. There's about 40 maybe more, reported cases of pets and condos, and the cases are all over the place. There's no consistency to them. You have decisions in every possible direction on pet disputes, and it would be nice to have a centralized place to get some consistency in the law and to reduce the cost of these disputes, because part of the problem with going to court is the cost, and normally the trade-off is you get some certainty, but there's no certainty in pet disputes. So you never even know if you're going to succeed or not, because it really just depends on the day and the judge and how things go for you. So with that in mind, I think it's a really good thing. It's taking a very sore area of disputes between owners and condominium corporations, and it's placing it into a venue where people can sort of air their grievances and get these things solved in an expedited manner. So it's great. I'm really happy. Cat for pet disputes. Wonderful. Okay, we had a few more questions come in. Dorothy, has anyone opened their gym? If so, what advice do you have? I have some advice for opening gyms. It's set out in quite a bit of detail in our most recent couple of weeks FAQ, and I'll just sort of run through it with you. But basically, there's provincial guidelines, and the guidelines, it's my understanding that they're created for commercial gyms, but if you look at them, there's a lot of parallels to condominiums. So if you go through our weekly FAQ, we have a link to the Ontario guidelines for sport and recreational facilities during COVID, and then there's also an amended regulation. So those two documents, when read together, give the following requirements and recommendations. So one, gym users must maintain a 2-meter distance from each other. Maximum capacity must be restricted to allow physical distancing. Gym equipment must be cleaned and disinfected after each use. In my view, that it's sufficient to require in an amenity gym that the users disinfect before and after each time you use it. You wouldn't necessarily have to have a staff member from the condominium corporation doing the cleaning. It just has to be cleaned. It doesn't say by whom. So those are the requirements. And then when we get to the recommended regulation or the recommendations, remove equipment that's difficult to disinfect, for example, yoga mats. Consider a reservation system for using the gym. Leave enough time for cleaning in between reservations. So I have a client that has a gym that has sort of 3 separate sections, and they decided that they would allow 3 people at a time in the room, and you would have to reserve your spot for an hour. And then, in between each hour reservation, there's like a 10-minute or 15-minute gap for cleaning. That seems to me to be a great solution. Rearrange gym equipment to facilitate physical distance. That makes sense. Require a mask or face covering. Again, it says, except while engaged in intense physical activity. I think you could require a mask at all times if you're in any municipality that has a mask bylaw, like City of Toronto, York Region, Mississauga, all those places. Avoid fans that recirculate air within the gym. That's sort of a counterintuitive one. Most people think that the fans would help, but they don't. They make the air spread around, which is not what you want. And then implement a health screening questionnaire. So before you can reserve the gym, you have to confirm that you meet all the health screening questions, which many of you will be familiar with by now. Do you have any symptoms? Have you traveled? Pending test, all that stuff. Okay, so those are my recommendations for opening a gym. Question. What if we do not have proof of a water leak into the unit below at the time it happened, when unnoticed and below the heat pump above? That's a difficult question. I would want to look at all the facts and circumstances to try and figure out how to deal with that. It's sort of hard from the description you've given me as to what the exact thing to do is, but you want to be cautious. And if you have a leak and you don't know the source, you want to get a report stating the probable source before you start charging people back for leaks from their units and things like that. It only makes sense that you would want to know the source and have it fixed before you do the chargeback. Okay. Paulette, I have a corporation that has 5 positions open. They will get in by acclamation for two for 3 years, 2 for 2 years, 1 for 1 year. How should the terms be decided upon when there is no election? So you should pass a motion at your meeting, Paulette, that says that the candidates are permitted to decide between themselves who gets the longest terms, and then the candidates will sort themselves out. If the owners don't care, and if the candidates will not agree to that, then you do have an election just for term, right? That you have 5 candidates for 5 positions, and whoever gets the most votes gets the longest terms. If the candidates cannot agree amongst themselves who gets the longest terms, then you have an election to choose the terms. That's what you do. Jean, stacked townhome, unit owner above is upset with unit owner below, calls the owner above in public, but not directly, a derogatory name. Police are called. Is this a corporation issue, quiet enjoyment, or is this civil criminal? Owner, spouse of board member, wants the corp to force quiet enjoyment. We feel this is civil criminal. Okay, Gene. So you want to look at your rules and see what your rules say. Just want to reread your fact pattern here because it's a little unusual. Owner below calls the owner above in public, but not directly, a derogatory name. So it's like John and Mary are fighting, and John says to Steve, Mary is a derogatory name. That to me is not a corporation issue, if that's what happened, right? If I'm understanding correctly. So it's like John is being rude and insulting, but not to the person, not harassing them, just like in his own private life to other people, but publicly. Not a corporation issue. You would be concerned if someone is like making noise to disturb their neighbor, banging on the ceiling, knocking on their door, going up to them on the common areas and threatening them, making them feel unsafe. That's a corporation issue. That's Section 117 of the Condominium Act. Threatening people, any of that kind of stuff. But, indirectly being rude or whatever, no, not a corporation issue. So it's sort of a fine line. But, looks like your situation runs close to the line, but based on the way you've described it, if I understand it correctly. No. KB, during electronic meetings, votes are taken by a poll. Do you anticipate challenges on these types of votes? That's not how we do electronic votes in electronic meetings. We don't use the poll feature on Zoom or whatever. We have our own independent third-party voting software, and the people get an email, and that email is secure, and then they go and they vote on an alternative secure website. So that's how we do it. We don't do polls. We tried it. We thought about it. We tried to make it work, and we found that it just couldn't work. So we do e-voting using separate specialized voting software. But if you're going to use during polls, you better make sure that it's a really small meeting and you're not having potential for fraud. And the reason why you can't use a Zoom poll to do your voting is because you cannot control who gets the Zoom poll. Like everyone who's in the meeting can get the poll. So if you have more than one person from a unit watching the meeting, then you can get multiple votes from the same unit. So that's why Zoom polls don't work, and that's why you have to use independent third-party voting software when you do your electronic meeting. And if you could just do voting by Zoom polls, then you wouldn't need meeting hosting services or anything. You could just do it all on your own, but you do need this extra stuff, and that's why there are companies like HLD Meetings and Condo Voter and whoever who are providing these services to people. Because trying to do it the other way just doesn't quite get you where you need to go. You get close, but not all the way there. All right. So that looks like all the questions. So 12:38. That's about as far as I usually go in terms of questions. I'm really happy with the questions today. Everyone gave me really interesting stuff to talk about. Cat stuff, great news. I'm sure you'll all be hearing more about that. So it's really nice. All right, everyone. Thanks so much. We will see you next week. Keep an eye out for our updated FAQ. We'll look into this expansion of the cat jurisdiction. We'll have more to say about it soon. And everyone, stay safe and keep sending us your questions. Keep coming to watch. And we really like this opportunity